Let's go here and then back and over here. 1, 2, 3.
Assuming that your, let's assume that your claims about the SCO's ownership of copyrights are held to be valid. Is it then possible to somehow clean Linux of that code, or are we all in kind of limbo until we know, until all this winds up in the courts and we know it's legal? Because apparently much of it was created as free software without the contributions of code that originally came from Unix. And is it possible to go back to that state, or would the act of doing so reveal the code that you're forbidden from revealing by your licenses?
Part of the reason we got into the licensing program is that we had people actually asking that very question. Is there some way that I can license this from you and feel free that I can just run this stuff irrespective of what happens in your court case? If you look at Unix and Linux, if you go down to the bookstore right now and look for a book on how to program in Linux, typically it'll say how to program in Unix/Linux, okay? Making the point that Linux is a clone of Unix. We absolutely recognize that there have been many contributions and many works, starting with Linus and going to many people around the world that we don't have anything to do with, and we're not trying to say we have anything to do with it. All we're trying to say is the property that we feel is in there that is violating our rights, we want to get compensation for that.
But if people agree with you and they agree that your property is in there, but they don't want your property, they just want everything that's not your property, how can they get that? How can they go back to the free, at some point, somewhere in the beginning, there was a Linux that had no proprietary code in it because it was all Linus and anyone else who was making free contributions.
Right.
And along the way, there have been many similar contributions. So how can we get
that's
back
a good
to
question.
that level?
So what we've said is, like in the case of the IBM code that we claim is in there, that we think is material, when we say it goes into a high-end, high-power processing system, we think that if you rip that code out, it's going to make Linux not nearly as attractive. But if the common wisdom is to take that out and to go down that path, assuming we win that court case, then absolutely that's something we'll sign up for. Back here and down.
Hi. I understand that you insist on the respect of copyrights, and I think everyone in this room would agree with you on the respect of copyrights. However, SCO is currently distributing GPL software products such as Samba in some of its own SCO products. Since you believe that the GPL is invalid, I was wondering under what license are you currently distributing Samba and other such products?
Sure. Darl's mentioned earlier that SCO has participated in many open source projects, has made contributions to open source projects, doesn't have issues with open source projects that, the IP basis of that work is sound. Same with our participation with Samba and with other GPL or other open source projects. So we continue to participate in some open source projects, Samba being one of them. And we do have concerns with the GPL, and the GPL may have to be reworked, changed, a new license put in place. But in terms of, as far as we are aware right now, there are no issues in terms of IP with Samba that we're aware of right now, and so we continue to participate with that. In terms of the Linux kernel, we specifically have an issue, and that is a completely separate problem. So you can't drag it to the extreme and say, oh, therefore all other projects, all other issues are, completely out of bounds. We've participated, we'll continue to participate. So as far as we're concerned right now, until we have evidence to the contrary, there's no issues as far as we're aware of with Samba.
Right here.
Hi, my name is Ben Adida. I'm from MIT. You're right that the GPL has not been tested in court, but then I would say that neither has your claim about copyright. At this stage, your claim about copyright over Unix, which you're more than welcome to make, has not been proven. At the same time, you've kind of cherry-picked various opinions from the open source community and blamed the whole community for these random little attacks. But the actions of your company, SCO, as an entity, have included tactics such as sending letters to various users of the software. And as a company, before your claim to copyright has been made in court, you've tried to intimidate people into paying you $700 at a discount price for Linux and $1,200 at the full price. And you make this claim based on this idea that the GPL has this warranty disclaimer, which has no relevancy whatsoever to copyright. It's about the way the software functions, not about the copying of the source code. So how do you justify going after people before you've made your claim, going after users, people who believe they were in the right because they dealt with Red Hat, because they dealt with SUSE and acquired this software, and how do you justify that kind of action?
Well, I think you bring up a number of good questions there. Let's go back to the first one, which is we sent out letters to users saying we've got a problem and pay us money. If you go back and look at the letter we sent out back in May, we didn't say a word about paying any money. We said we feel like we have intellectual property problems inside of Linux. Your point that this has not been tested with end users is a good one. We are going down that path. We have said we're going to go down the path and we're going to test that, and that's coming up here within the next few weeks. The question earlier is, what are you doing to mitigate your problems? What are you doing to let people know that you have problems? We sent out letters in December saying, specifically, people have clamored saying, SCO won't even show where the code is. We sent out letters that said, here are 75 files. Linus stepped forward and said 2 of those that he did. He didn't comment on the other ones. Not to my awareness. Maybe he has, but on the one that I saw, he said 2 of those I remember writing myself. Great. Somewhere in America, there's going to be a judge that's going to sit down and you know, the rubber hits the road when you get in the court system. And we're going to be there. And so on the contract issues, we have various contract claims with various vendors. We've isolated them down to IBM because we feel that's where the biggest area of concern is. On the copyright side and on the end user side, we'll be in a courtroom somewhere in America soon, and that will play out. There was a question back up here. Oh, here's where I was at. Go ahead.
Thanks. I'm Derek Bambauer, a third-year student here at Harvard Law, and would like to thank Joel and thank you for bringing the debate here to campus. I think that's great. A question. If we assume for the moment that you prevail in the suit against IBM and that you hold copyright such that Linux has infringed, if I go to the coop and I actually purchase a Red Hat box, so a box version, or over the internet or somewhere, I buy a PC that has Linux preloaded on it, would it be your position that by either installing the operating system on that Red Hat CD or by using the OEM version of Linux that I have violated your copyright?
I'll take that one.
Sure. Yeah, our opinion is that if it's proven that our intellectual property is in Linux, and I'd like to separate out 2 points. One, you're dropping it all into our case against IBM, which is a contracts case involving their violation, as we've alleged in our lawsuit, of certain portions of the contract, specifically confidentiality of material, derivative works, those sort of things. So let's separate out the IBM case, and that stands on its own. In terms of separately copyright issues, let's say that is proven as we go forward with as we prove our copyright issues. We would have a basis to then come back to, as we've stated, commercial users of Linux. If you're using it for educational purpose, we're probably not going to deal with you. If you're using it in a large commercial environment and getting a great deal of economic benefit of the use of some of our portions of our intellectual property, we will probably have an issue with you. And at some point, we may choose to enforce those rights. So that's what it comes down to.